Hello, this is Reporter 7. Today I am reporting on a case from Huntsville, Alabama. The case of Marcus Miller versus the state of Alabama. Mr. Miller was convicted and sentenced to life without the possibility of parole on April 9, 1999. By DA Starnes' use of an alleged prior felony over Mr. Miller objection. The DA office of Madison County, Alabama submitted certified copies of the would-be prior in which the sentencing court accepted. Mr. Miller began to pursue his case pro se and obtained records from the Alabama State Archives to prove his objection to the use of the prior conviction was unconstitutional. Please keep in mind that Assistant DA Starnes swore to uphold Alabama white supremacists' laws as declared by John B. Knox, an Alabama attorney at the 1901 Constitutional Convention. On Jan. 2005, Mr. Miller petitioned the court via Rule 32 of the Alabama Rules of Criminal Procedure challenging the validity of the alleged prior conviction and sentence as void on its face. Surprisingly, the state agreed, in which resulted in Mr. Miller being resentenced to life with the possibility of parole in May 2005 and February 2006. Mr. Miller's new sentence afforded him with the opportunity to be considered for parole. In August 2008, Mr. Miller went up for parole, in which he was denied and set off for 2 years because DA Starnes represented to the parole board that Mr. Miller's sentence was in error. In September 2008, Mr. Miller received a letter from the Circuit Court Clerk's Office of Madison County. Mr. Miller was informed that his sentence had been converted back to life without the possibility of parole. Mr. Miller was dumbfounded as to how could the state have him resentenced outside his presence and after well over 30 days lapse of his Feb. 2006 resentencing. Mr. Miller filed another petition under a different set of facts to the Madison County Sentencing Court and returned back to open court. This time the DA Starnes tag team Mr. Miller with DAS Burnett, in which Miller acting pro se was no match for the both of them. The state prevailed against him. Mr. Miller did not give up. He filed another petition and was returned back to court in 2015. This time it was DAS Burnett against Mr. Miller, in which led to DAS Burnett being outwitted by Miller. However, Circuit Court Judge Pate could not come to terms with Miller's outsmarting her colleague S. Burnett, so she denied Miller's claims out of spite and to cover up DA Starnes' fraud upon the court. Mr. Miller by then had been before 5 different judges. The fourth one was Judge Pate. Mr. Miller filed a motion for recusal with smoking evidence he could not receive a fair determination with Judge Pate. The motion for recusal was granted and Judge Hall was now over his case. In 2018, Mr. Miller was returned back to court. Judge Hall heard his case but refused to enter a ruling then because the clerk's record was in disarray. However, after Mr. Miller's return to court in July 2019, Judge Hall granted his petition and resentenced him to life with parole eligibility. Mr. Miller went up for parole in September 3, 2022 and was denied in retaliation for being a uppity smarter mate that fought tooth and nail against his injustice. The state actors are true to Alabama's 1901 Constitution white supremacy regime and, like in slavery days, judicially and systemically lynch Mr. Miller for daring to enforce his constitutional rights. Thus perpetuate the systematic stripping away minorities' lives by lock 'em up young and bury them old in prison. Mr. Miller has been locked up over 24 years day for day and has completed a paralegal course. Surely this brave man should have been released from prison, but he is being held as retaliation because he refused to lay down like the good modern-day slaves in prison, content with the status quo. Until the next time, bye from Reporter 7.